Hey y'all, what's good? Welcome back to my channel. Thank you so much for tuning in. I hope you all are having a great week. We are midway through, you guys, halfway there to the weekend. I just want to take the time to thank the 276 subscribers that I have now. Okay. Thank you guys from the bottom of my heart. It means so much to me that you guys are enjoying my commentary. And we just gonna ride this thing on out. Okay. So today we are going to talk about Darrell Brooks, of course. Um, but this video is going to be a little different from my other ones because I'm going to be providing some case law as it relates to his wanting to represent himself pro se. Um, and then we're going to actually watch the first hearing that the colloquy/hearing that was conducted between the state, the defense, and Judge Doro when she actually had to um, cut the colloquy early because he was just uncooperative. And I have a theory about why. So we're going to talk about all of that, okay? Um, and there will be a part 2 because the colloquy ended up being 2 days, and they're both an hour and some change, and I'm not making a 4-hour video. This video will probably be a little over 2 hours, maybe closer to 3. However, you can, watch it at your leisure, stop and start whenever you feel the need to. Okay, so we're going to jump right into it. So, as you guys may or may not know, Darrell Brooks was originally appointed two criminal defense attorneys. One being Jeremy Perry, who has 21 years experience as a lawyer, and the other one being Anna Keys, who has 14 years experience. So, one thing that's important to note is that when you are appointed a lawyer and it is being provided to you via taxpayers' dollars, meaning that it is not an attorney, it's not an attorney who is a private attorney, someone that you hired on your own. They do not work for you. You are not at liberty to tell them what you want them to do. Okay. They will uh, demand for discovery so that they can go through the evidence against you. They will then, hopefully, depending upon the charges, go to the prosecution and see if there is possibly a plea deal that they can request on your behalf. If that is unavailable, then they will use the resources that they have to try to formulate a defense for you. Another thing to note is that just because they are criminal defense attorneys, it does not mean that they feel that you are innocent, okay? Their job is to take the evidence that they have and try to formulate a defense, okay? So, some of the defenses that they can use or some of the things that they can request are reduced sentencing, a reduced sentence with time served, and then you can be remanded to a diversion program. So, that could be like drug therapy, some type of mental health stay at maybe a clinic or something like that. They can file a motion for a mistrial due to technicalities. Maybe the evidence just doesn't suffice to find you guilty or something like that. They can, again, see if they can get a plea deal from the state. And last but not least, they can see if they can get an expert to declare you mentally incompetent and you are unable to attend trial. And so what you would do is get mental health treatment, and then they will reevaluate you to see if you're competent to stand trial. So in this case, his attorneys decided it would be a good deal to just do an NGRI plea, which is not guilty by reason of insanity. So basically, what that means is that you are um, basically admitting guilt, but you are saying that you were insane at the time of the crime. Okay. With this, you would have to have experts to come in and evaluate you. And that means that the state will then be privy to those findings. They can cross examine those witnesses to try to shut down those claims. All right. I believe this is one of the reasons why Darrell Brooks decided to represent himself because he did not want the state to have any opportunity to try to dismantle his whatever he felt his defense strategy was, okay? And so that is why I believe that is one of the reasons why he chose to part ways with his defense attorneys. Also, I believe that given his personality disorder, he felt that, he would not be in control again because the attorneys are in control and you're not going to tell them what to do. So he would lose control. He already has increased paranoia as a result of his personality disorder. So his idea was to fire his attorneys. No attorneys means that he does not have a defense, and then he is able to throw the trial due to his quote unquote incompetence. Darrell Brooks knew that he had the right to self representation. He knew that he can prove mental incompetence. And if he could prove mental incompetence, that the judge would have to provide him with standby counsel. And also, he knew that his continued outbursts would throw the trial, causing the judge to appoint new counsel. Okay. And I'm going to explain that in greater detail in a little bit. So, we're going to get into a little bit of case law, you guys. I do have notes, so you're going to hear me shuffling my papers, but it's so much information that I want to go over that I had to write notes. I have 4 pages of notes, front and back. Okay, so let's just jump right into it. So Darrell Brooks' pro se waiver was approved on October the 3rd. So I want to get into a little bit why he is able or was able to represent himself pro se. So we're going to look at Ferretta v. California. I'm going to share my screen so that you can follow along with me. Give me 1 second. Okay. So Ferretta v. California was a case where this individual was charged with grand theft. He originally had requested to represent himself pro se. The judge questioned to see if he had knowledge of hearsay and other court procedures, and ultimately the judge determined that he was not intelligently and knowingly able to waive his right to counsel. So he was appointed a public defender and he was convicted. So he filed an appeal, he got another trial. With that trial, he was able to get a standby counsel and he represented himself pro se. However, there was a lot of back and forth. So there were times where he agreed with his counsel and he allowed them to help him with different aspects of his case. There were other times where he wasn't in agreement with them. And so he didn't want to have counsel. There was a back and forth throughout the entire thing. Unfortunately for him, he was found guilty again, and so this time now he has appealed to the Supreme Court to hear his case. So the question for the Supreme Court, the question that they had to consider when taking on this case, excuse me, was can a defendant be denied the right to present his own defense and be forced to forced to accept representation by counsel? So, per the Supreme Court, a defendant in a state criminal trial has the constitutional right to defend himself when he voluntarily and intelligently wants to. Okay. Knowledge of the hearsay rule and court procedure are irrelevant to voluntarily waiving counsel. So, keep that in mind. So, there are elements to self representation. In order to be able to represent yourself pro se, you have to prove competency, you have to knowingly give up your right to an attorney, and you have to understand court proceedings. So I want you guys to think back to all of the times when Darrell Brooks said he didn't understand. Even during the colloquy that he had during his pro se hearing, his hearing to withdraw counsel, he continuously said he didn't understand. The waiver form that he had, he crossed out um I don't understand and put I inform. There was a reason for that. Okay. So now we want to understand what does competency mean? Okay. Your right to self-representation hinges on competency. Competency is based on age, level of education, familiarity, I can't say that word right, with English language and the seriousness of the crime. Okay? So there is no expectation whatsoever that a defendant who wants to represent himself pro se have the same level of knowledge and skill as a skillful and experienced attorney. All right. And so this is step one where Darrell Brooks went wrong. Now, he knew that the law required that he be allowed to represent himself. However, he, of course, did not have any type of skill set as it pertains to the law. And so that's where he effed up at. We know that, we've seen that. Okay. So, despite his behavior, he has the constitutional right to represent himself. And so, we're going to go into some more case law surrounding that. We're going to look at Pickens v. State. I don't think I have that pulled up, so I'll just give you what it is. So basically, it's a precedent that allows the judge to determine the competency of a defendant prior to waiving counsel. So a precedent is when there have been cases prior to a current case that is being tried. They use that as an example to make decisions under the law. So this case, Pickens v. State, 1980, it is a case that took place in Wisconsin. Okay. And there was basically a defendant who was unsuccessful at representing himself. And so on appeal, he did was able to seek counsel. And so the question was, how are they able to determine competency as it relates to representing yourself pro se? All right. I hope y'all with me so far. So, someone who is competent to trial must be oriented to time, place, and has a reasonable degree of rational understanding. Again, this takes place at the colloquy that we are getting ready to watch. So, I'm going over this so that while we're watching it, hopefully some of this stuff you remember and it'll make sense in a minute. I promise you. I know it's a lot. Okay. So now we want to understand um what do we want to understand now? We're going to look at some more case law. Give me a second. So this one is McCaskill and Wiggins. So this I didn't pull that up either. Okay, well, I'm just going to give you a synopsis of that. So there was a defendant who robbed the store. He initially waived his right to counsel. Okay, it's coming back now what I want to say about this. So 2 months prior to trial, he changed his mind and he requested counsel and then to rescind the earlier waiver. So the first waiver was that he didn't want counsel. 2 months later, he changed his mind and decided to have counsel. Okay. And this is the guy, I made a mistake earlier, so let me retract or recant. This is the case where the guy went back and forth about having counsel and not having counsel. And basically, he lost his case. And he said that he lost his case because counsel was interfering with, um, his defense strategy, okay? The other case that I gave you, Ferretta v. California, was just, a case where they needed to decide if a defendant can be denied his right to representing himself and should he be forced to, and the answer is no. It is against the law to force somebody to have counsel. Everybody has a right to represent themselves. Indiana v. Edwards, did I go over that yet? Indiana v. Edwards was the case where you have to prove if the person has mental incompetence or not. So I think I got ahead of myself. So I apologize. I'm sorry. McCaskill v. Wiggins is the case where the defendant basically bounced back and forth between representing himself pro se and using standby counsel. And then eventually he blamed his counsel for interfering with his defense strategy. And so he appealed all the way to the Supreme Court. And the Supreme Court basically says that the Sixth Amendment does not guarantee the right to self representation completely free from the presence of standby counsel. Okay. So he lost his case. Now, you're probably wondering, what the heck does that have to do with anything? You talking too much. I'm lost. All this law talk, get to the point. I'm getting there. Okay. My question is, could it be that Zarrell had his own defense strategy and felt that counsel interfered with his strategy? Okay. Remember, defense attorneys will come up with a strategy where they feel that even if they can't get you completely off, maybe they can get your sentence reduced. Maybe they can get a hospital stay for you. They're trying to do the best they can. But I believe that Darrell Brooks, okay, had his own strategy and they were against that. And that is why he decided to represent himself pro se. So, we think about antisocial personality disorder. Some of the characteristics are that they become aggressive, angry, arrogant when they aren't able to control a scenario. This is evidenced by Darrell Brooks saying when Judge Darrell was informing him of the experience, the collective experience between the state, he said, "It don't make me flinch one bit." He repeatedly kept saying that, that's fine," swiveling in the chair. Instead of saying, when she asked him certain questions, he said, "I heard you, but I object," meaning that, okay, I hear what you're saying, but I don't agree to it, so I'm going to object to it. And then that means I'm going to get my way. On the form, he kept crossing out that he understood and wrote, "I'm informed." He argued her down about the difference between per, and pro se, which we know those are two and the same. And then again, swiveling in the chair. To me, that was childlike because he's not in control and he's not comprehending what's going on. He wanted to show the judge that, "No, I am not competent, okay? And so you gotta throw this trial." I hope it's all coming together. I'm doing my best. All right, my next theory is the outburst, okay? Listen to this and listen clearly. The law states that no one should be subjected to trial who lacks the capacity to understand the nature and purpose, y'all remember that? Nature and purpose of legal proceedings against them. How many times did Darrell Brooks say, "I don't understand the nature and cause of these proceedings"? Do you know why he said that? Because he knew that it would be against the law for them to continue with this trial if he did not understand the true nature and cause of the proceedings. We all know he understood very well. However, if he repeated that line over and over and over again, he knew eventually she's gonna have to either dismiss this trial or she's gonna have to get me standby counsel. Why does he want standby counsel? That is why I brought up the McCaskill and Wiggins case. In his mind, I believe, this is my theory, that he would have had the opportunity when he became flustered with all of the legal jargon, with all of the evidence, with learning how to object, with learning how to cross examine, with learning how to do direct examinations. He wanted the opportunity to say that I am incompetent, okay? I don't understand. His behavior was so egregious enough to where Judge Doro would have had to forfeit his right to represent himself pro se and assign him an attorney. Darrell Brooks, being Darrell Brooks, would have used that attorney up. Okay. He would have got him to show him how to present evidence, explain things to him. He would have tried to fire him again or sit him to the side so that he would be able to control the scenario again with the knowledge that he got from his attorney to try to present his case, and there would have been a back and forth. Okay? Y'all tell me what y'all think about that. Okay? If Darrell Brooks shows out, it becomes so egregious the judge can forfeit his right to represent himself and he will be forced to have counsel. Y'all let me know what you think about that. Okay. If he is found to be incompetent, he has to have counsel. It is the law. And I already just said this. What can counsel do for him? Explain the proceedings, explain when and how to object, explain what evidence is inadmissible and admissible, can help him file documents, okay, can explain the meaning of hearsay to him, can help him with presenting evidence. He can toggle between the two. He can delay the case because he does not understand the true nature and cause of these proceedings. Okay. This is my theory. Y'all let me know if it's making sense or not, or, whatever. Leave your own comments how you feel about it. Darrell Brooks knew what to research, y'all. He knew what to research. His lawyers researched certain things. He was not able to understand it at his 12th grade level or whatever. What did he drop out ninth grade? I don't know. He wasn't able to comprehend it enough to present it. He had it in front of him. He knew what to research. Somebody on the phone every day was giving him information about what he could say in court. It's just that he was unable to say it because of lack of insight and poor thinking skills. Okay. He was raised to shift the blame. He's mentally immature. He's full of paranoia. He lacks social skills and he's a master manipulator. And those things interfered with his ability to present this evidence, these theories, this case law that I just gave y'all. Okay. I'm not excusing his behavior whatsoever, so don't take it as that. When you are defending yourself, you can appoint a lawyer at any time. We know that the judge can't give legal advice. Example, okay? The judge can't tell him what to file, how to file it, when to file it, but she can explain the grounds of objections. He didn't like that, but his pride was in the way. And so, therefore, he couldn't say, well, you know what? I'm in over my head. I need an attorney. After she told him, you can always consult with an attorney to get the legal advice you need. He's too childlike to say, "You know what? You're right. Can somebody help me get an attorney? I need an attorney to explain some things to me." So instead of that, he reverts back to being a child and he throws these tantrums because now he believes, okay, well, if I throw a tantrum, if I argue her down, if I exhaust everything, if I make the state slip up, if I can just push a little more, I can throw this trial. Okay. In his mind, it's easier to show out and force the judge to appoint an attorney. Darrell Brooks is envious that the prosecution can present the case, but with his lack of thinking skills, it makes him violently angry, y'all. His paranoia grows and he throws a tantrum, hoping to force the judge into a decision. That is my theory based off of case law, based off of observation. Y'all, let me know what y'all think. Let me know what you think of my research. I appreciate y'all so much. We are now going to jump into this colloquy. The colloquy is an hour and 9 minutes. I am going to provide my commentary throughout. So, again, if you are not able to watch this video in its entirety, that is quite okay. You can push pause, stop, rewind. I want you guys to let me know what you think I did with my research skills. Did I do okay? Do you need a little bit more clarification? Do you feel it's BS? Y'all let me know. Okay. I am in school. And so these are some of the things that we do in school as paralegal students. We are given case studies where we have to dissect them and we have to, um, you know, in one case side with the prosecution, on the other hand side with the defense, and come up with a strategy using case law and the evidence that is readily available. So please let me know how y'all think I did. Okay, I did a lot of work or whatever. And I'm a little proud of myself. I'm a little proud of myself. I may not be completely correct, but hey, when you're dealing with the law, 99% of it is a theory. The rest is what you can prove in court. I'll say 0.5%, and the other zero point 0.5 is how the jury feels. Okay. So you let me know how I did. Anyway, that is enough rambling. I'm going to jump to the colloquy. We're going to watch it together. And of course, I'm going to provide my commentary throughout, and then I'm going to let y'all go. So give me 1 second.
Motion before the court. I don't believe I need to put any of the substance of that on the record unless there is a request from either of the parties. I do not intend to go over any of the substantive issues that are remaining in this case, other than the motion to withdraw. That includes the various filings that the parties have made and any other open issues that we have at this time. I need to first address the issue with Mr. Brooks and the motion to withdraw. I do want to start out with you, Mr. Brooks, and ask you, is it your desire to represent yourself in this case?
Uh, It is, I would like to proceed in this matter, for prior persona, not pro se.
Say that last part again.
I would like to proceed in this matter in pro per, not pro se.
So you're going to have to tell me what you think that means.
It is me exercising my right to defend myself, to represent myself as a sovereign citizen.
Okay, so I'm gonna stop right here real quick. As you can see, she is doing a colloquy with him, and this is her asking those questions that I told you about to see if he is competent to represent himself. You can see he's done some research or what have you, or he's gotten some advice from someone. He's able to clearly explain to her what he chooses to do and why. And so she's able to check that box off of that waiver form. Okay, so let's continue.
So essentially, this matter today would be me appearing by special appearance.
You have an absolute right to have an attorney represent you. It is protected not only by the Wisconsin Constitution, but the United States Constitution. Do you understand that?
I do understand my rights under the United States Constitution, yes.
Did you hear what I said?
Repeat it.
Do you understand that you have the right to have an attorney represent you, what we call the right to counsel?
Under the Sixth Amendment, correct?
Under the Sixth Amendment, the 14th Amendment, and the Wisconsin Constitution.
So again, you see he's done his research. He knows that under the Sixth Amendment, by law, he has the right to represent himself and he can waive counsel. So I'm not saying I'm impressed, but I mean, let's continue.
As well. It's a well-established right that a criminal defendant has. Do you understand that?
I'm aware, yes.
Do you
I'm
also
aware
understand?
instead of I understand. What did I tell y'all about the I understand? Go back to that long speech I gave y'all in the beginning as to why he won't say I understand.
Understand that you have the right to represent yourself.
I'm aware of that as well.
I have before me a motion to withdraw by your attorneys with the sole basis that is listed that you want to represent yourself. Is that your understanding as well?
That isn't entirely how the issue came about. I think it's important for that to be on record. Um,
I'm not asking you to divulge attorney-client privileged information. Do you understand that?
so essentially, what is the question?
Well, I want to make sure you understand you have these competing rights. It is recognized in our case law from the United States Supreme Court, the Wisconsin Supreme Court, that there are these competing rights: the right to counsel and the right to self-representation, essentially to be your own counsel. Do you understand these competing rights?
I am aware.
Do you understand, sir, that you can't have an attorney and exercise that right and also exercise the right of self-representation?
I don't understand that.
So you started off this hearing by saying you want to exercise uh, this right to appear in persona today and act as a sovereign citizen. Sir, my concern here today is there's a request from your attorneys to withdraw from this case. Do you understand that's the request before me today?
I'm aware that they filed a motion to withdraw, yes.
And are you aware, let me back up. Have you seen that motion, sir? The written motion?
I have seen it.
Did they give you a copy, the paper copy?
I believe it was delivered to me in the jail.
Right, do you have that in front of you today?
No, I do not.
Madam Clerk, why don't you print off a copy and we'll give it to him. Just that. Well, it looks like Attorney Perry has put that in front of Mr. Brooks, along with the court is providing another copy. Mr. Brooks, can you acknowledge for me that you have a written copy of the motion to withdraw now in front of you?
Yeah, this is a motion to withdraw.
Are you able to read that on your own, sir?
Yes,
Have you read it?
Are you able to read that on your own? So basically, she's establishing that he understands the English language. He's able to read and comprehend what the motion says. Okay, this is important for her to know, all right, to establish competency. So she has to go over it like that. It seems like she's spoon feeding him, handling him with kid gloves. There is a reason. She has to be very careful, very meticulous, okay, and making sure that he understands everything that's taking place. He understands how to read documents, not only documents, court documents that can be very challenging to understand. He's able to read that motion, understand what it says, and that's why we're here today.
as of now, I have read it.
Do you understand what's in that motion?
Yes, I'm aware of what's in the motion, yes.
Is there anything about that motion you do not understand?
I'm aware, I'm aware of it.
My question is, do you understand?
I'm aware.
Do you understand what it says, sir?
It's clear to me what it says.
All right. So let me start off again by asking you, do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that
Again.
request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What don't you understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case. And I credit them with that. I'm appreciative of that. But it also should be said that there's a lot of things that I did not understand about the proceedings in a lot of the court cases. There were things that I didn't understand why there wasn't certain motions filed. There were a lot of things that I did not understand the totality of the meaning behind. And that is what kind of led to a lot of issues. But these were issues that were being raised for a number of months. This was not just something that sprung up out of the blue. And I feel that as my attorneys, that it would be essentially their job to make me aware of things that I do not understand. So that's where a lot of the questions come into question as
So
is
let me follow that up, sir. If I allow them to withdraw, you lose their legal experience, their specialized training, right? Their education, their work as attorneys. Do you understand that?
no, I did not.
So basically, what she's saying is that Darrell is saying that with his attorneys, he was not able to understand certain things, and he felt as if they were not able to explain them to where he could understand them. And so Judge Durrell now is saying that it still doesn't make sense because even if you don't necessarily understand how they are explaining information to you, you going pro se is not going to help but hinder you because now you don't have anybody to help you because she, as we know by now, is not going to appoint him standby counsel. And again, instead of him just maybe asking for new attorneys that can maybe fit his personality disorder or explain things to his level of understanding. He is too arrogant and too childlike to say that. So instead, he just wants to throw them away altogether and make a mockery of the court.
Understand.
So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
So in order for me to evaluate whether that's appropriate in this case, there's certain things that I need to go through with you and on the record. Okay, do you understand that?
Yes, Your Honor.
So let's start with the charges in this case. And I'm going to group.
Okay, so again, this is the part of the colloquy when she is going to determine his competency based on the seriousness of their crime. So we've already established how old he is, the level of education. We already know that he can read and comprehend English. And so now we're moving on to the seriousness of the crimes.
Group them together. And if you have any questions, you need to ask me. Do you understand that?
Yes, ma'am.
So first of all, sir, you are charged with 6 counts of first degree intentional homicide, use of a dangerous weapon. Do you understand that?
No, I do not. And what I don't understand is the nature and cause of the charge.
What I say? What did I say? He doesn't understand the nature and cause of the crime. He started saying that early on. He started saying that early on. Okay. If he tells the judge that I don't understand the nature and cause of this crime, guys, what did I tell you what happened? Where my notes at? Where my notes at? The law states that no one should be subjected to trial who lacks the capacity to understand the nature and purpose of legal proceedings against them. Okay. He's starting off early in hopes that she would just throw it all out. Yes, I want to represent myself pro se. However, I don't understand what the hell is going on. So what are you going to do? You going to throw this trial out or you going to let me act a fool? You pick.
Have you been provided with a copy of the second amended criminal complaint, sir?
I cannot say that I have.
I have a copy for you. It was filed on January 12 of 2022. I'll have my clerk hand it to the bailiff. You will be provided with it. While we're giving that to you, Attorney Perry, have you provided Mr. Brooks with a copy of that previously?
I believe so. I think he was also provided a copy of it in court.
I would like to say though, since you said January,
That was filed on January 12th, 2022.
part of the,
So, sir, let me focus you back. I'm interrupting here for a second because I want to focus on this document. So this particular document was filed on January 12th of 2022. Take a look at it. This document details the factual basis the state is relying upon to support each and every one of the charges.
So basically, they've already come up with a defense strategy for each of the charges that he faces. What was it, 77? They've come up with a defense strategy for each one. Remember, I told you that my theory was he did not necessarily agree with those defense strategies that they worked so hard to come up with. And so that is why he wants them out of there because he is a control freak. He's not able to control the narrative. He knows, and I'm sure they told him, we do not have an adequate defense for you outside of possibly saying that you were insane at the time of the crime. We know he was not insane at the time of the crime because 4 experts sat him down and interviewed him. Okay. So we can't use that as a defense anymore. So now he, being the person he is, doesn't want anything else to do with him anymore. I'm going to take all the research that you guys have done. I'm going to use it, even though I'm ignorant to the law. I can speak for myself. I know myself. Okay. I can articulate what happened that day, how I felt, prove everybody wrong, say it wasn't me, say it was an accident, all of the things, right? But he did not agree with whatever strategy they came up with for him because he is not able to be in control if they oversee his case.
Do you generally understand what a criminal complaint is, sir?
no, I do not.
Well, it's in front of you. Are you able to read it?
Now,
I
can
don't
read it.
mean this moment, but do you read, write, and understand English?
Yes,
Right? Remind me again of the last grade you completed
I have HSED,
and how many years in school did you actually attend before obtaining your HSED?
11 years,
How long after you went to school through 11th grade did you obtain your HSED?
immediately.
While you were in school, did you have any special education classes?
Minimally,
Any of those deal with reading or reading comprehension?
no, ma'am.
Do you believe you have any issues with reading documents in this case from a comprehension standpoint?
Absolutely not.
Okay, there it is. He has no problem reading and comprehending the documents that have been given to him related to this case. It's on the record, Zero. So we don't want to hear later. You don't understand and all of this stuff because that's not going to fly. It's on the record. You said that you read and write clearly, even though you do not have any education beyond the 11th grade. It seems to me that, and I know a lot of people are going to disagree with me. Y'all probably going to cuss me out in this school. You know, it's not the first time I've been cussed out, not the last time. I do not believe that Darrell Brooks is stupid. I believe that he is a criminal. I believe that due to his personality disorder, he is unable to maybe comprehend things as an adult. Okay, he's stuck in a childlike mentality. But I believe that had he applied himself long ago with help and guidance and staying away from dumb shit, he could have really been successful. Okay, he's sitting up here. He's answering the questions to the best of his ability. Like I said, he was able to research, get the necessary information so that, he can try to present it to the best of his ability. And so I don't think he's a dummy. I don't. I just think that he's a criminal that did some dumb shit and he's unremorseful. And I'll leave it at that.
Do you know at what grade level you read? Do you believe it's a high school educational level, a college level?
I don't know. Um, uh, I wouldn't be able to guess that off the top of my head, but I'm pretty sure that is adequate.
Any physical or psychological disability that would affect your ability to understand the paperwork that's given to you in this case?
Not paperwork wise, no.
Any physical or psychological disability that you believe would affect your ability to communicate in the courtroom, whether to me or in front of a jury?
Absolutely not. I'm doing a good job now.
You are answering my questions, and I appreciate that.
All right, arrogance. Pipe down. I just thought about something. I think that Darrell grew up without approval for, should I say approval? He wasn't rewarded or awarded for things that he probably did well. So, like when you have children or nieces and nephews and they do well in school, they won a science project competition, or, if they did well on a test or made a team at school or something like that. Usually most households will, find a way to celebrate their children. You give them maybe a dessert that they like, or you'll take them out to eat, or, something to make them feel special, appreciated, something to reward or award, I'm sorry, their hard work and their efforts. That comment he just made, I'm sitting here answering all of the questions right now. And then he smiled when she basically told him, good job. That to me lets me know that his inner child has never been in a position where he was awarded anything, if that makes sense. Things that he possibly did good in his life, I don't think were recognized. And that could be a reason why, hear me out, he went the other way. And y'all probably gonna cuss me out again. Go ahead. It's cool. These are just my thoughts. These are my thoughts. There could have been some neglect at some point in his life, in his childhood. And that inner child is just starving for somebody to tell him, good job. And so in this instance, even though this is horrific, the crime is horrific, this is not a joyous occasion at all. He feels good about himself that he's finally able to sit here and stand up for himself and show everybody, look what I can do. Look what I can do without the assistance of any of y'all. Even though we know he makes a fool of himself, in his mind, he feels as though I am doing something good. And look, the judge is proud of me. My mother may be proud of me because I chose to fire my attorneys and speak for myself at this level, at this caliber. It's food for thought. Think about it.
So, do you understand, sir, that you are charged with 77 different counts as it relates to conduct of yours that is alleged to have occurred on November 21 of 2021 in the city of Waukesha?
No, I do not understand, and I say that because I'm still trying to I would like to know the nature and cause of the charges.
Sir, listen to me and listen to what I'm asking you. Do you understand that you're facing 77 charges as it
No, I do
relates?
not
Hold
understand.
on, let me get my question out. Sir, and I will start a little bit more basically. Do you understand that you are charged with a variety of offenses due to conduct that you are alleged to have done stemming from an incident or a series of incidents from November 21 of 2021 in the city of Waukesha?
No, I do not understand.
Do you understand you're facing criminal charges, sir, in Waukesha County?
No, I do not.
So you have no idea that you are facing 77 different charges.
No, I do not. I would like that explained to me. If possible.
Have you asked your attorneys to explain that to you?
I believe I have a number of times.
I'm gonna do this a little bit differently, sir. Okay, you are charged with 6 counts of first-degree intentional homicide with an enhancer for the use of a dangerous weapon. The charges of first-degree intentional homicide, use of a dangerous weapon, carries a penalty of lifetime imprisonment. That means the information in this case alleges that you caused the death of another individual, in this case, 6 other individuals, with intent to kill, contrary to section 940.01, sub 1 sub A of the Wisconsin statutes. That's a class A felony. Again, upon conviction, you shall be sentenced to life imprisonment. That's as it relates to the first 6 charges. Do you understand what I've told you, just what I've advised you thus far regarding the penalties for the intentional homicide charges?
No, I do not.
You don't understand that these are punishable by life imprisonment?
I would like to still know the nature and cause of the charges.
Sir, I'm focused on the penalties right now and the charges. Please answer my
I
question.
do not understand.
Did you hear what I just said right now?
Absolutely.
You are charged additionally with 61 counts of first-degree reckless endangering safety, use of a dangerous weapon. These charges are Class F felonies, and upon conviction, you may be fined not more than $25,000 or imprisoned not more than 12.5 years, or both. This too has an enhancer for use of a dangerous weapon, which means the maximum term of imprisonment may be increased by not more than 5 years. Did you hear me advise you of these penalties, sir?
Yes, I heard you, but I do not understand the nature of the cause of the charges.
There are also an additional 6 counts of what is referred to in the information as hit and run resulting in death. Each one of these 6 counts is a Class D felony. And upon conviction, you may be fined not more than $100,000 or imprisoned for not more than 25 years, or both. Sir, did you hear me tell you about the penalties for these offenses?
Yes, but I don't understand the nature of the cause of the charges.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Did you hear me tell you about the penalties for hit and run resulting in death?
I don't understand the nature and the cause of the charges.
But that's not my question, sir. So stop playing games with me right now, okay? Did you hear me tell you the penalties for hit and run resulting in death?
Doesn't mean I understand.
I'm not asking you if you understand. I'm asking you, did you hear me advise you about the penalties? Are you able to hear me right now?
Yeah, I can hear.
Did you hear me advise you about the penalties for hit and run resulting in death?
I don't understand the nature and cause of the charges.
Again, sir, did you hear me right now?
I heard you right now. Yeah.
Did you hear me tell you the penalties? Yes or no?
Yeah, I heard. Doesn't mean I
And it's,
understand.
I'm not asking if you understand. So you're the one who wants to represent yourself in this case. So I need to go through all of the penalties with you. There are 2 counts of felony bail jumping. Each one of those counts is a Class H felony, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 6 years or both. Did you hear me tell you these penalties just now?
I don't understand them.
Did you hear me?
I heard you.
There are also 2 counts of misdemeanor battery domestic abuse. Each one of these offenses is a Class A misdemeanor, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both. And because each of these charges is an act of domestic abuse, costs upon conviction would include the domestic abuse assessment imposed under Wisconsin law. Do you understand, sir, what I have just told you about the penalties for misdemeanor battery?
No, I do not.
Did you hear me?
Yeah, I heard you.
Sir, I calculated the exposure for all of these offenses in 2 ways. In Wisconsin, when a person is convicted of a felony, under truth in sentencing, there's a maximum term of initial confinement and a maximum term of supervision that a court can order. So for example, for a lifetime offense, such as the Class A felony for intentional homicide, obviously the maximum is life. Do you understand that?
No.
Did you hear what I said?
Can you repeat it?
For a Class A felony for first degree intentional homicide, do you understand the maximum is life imprisonment?
No, I do not understand.
Did you hear me?
Yes, I heard you.
For the first degree recklessly endangering safety charges, if I were to calculate all of the imprisonment that you face from a maximum standpoint, it would be 762 and a half years plus an additional 305 years for the enhancers for use of a dangerous weapon. You understand that?
No.
Did you hear me just now recite that though?
Yeah, I heard you.
For the 6 charges of hit and run, the maximum exposure that you face for just those 6 offenses alone is 150 years. Do you understand that?
No.
Did you?
Okay, so I just wanted to stop real quick to If you guys are watching, I don't know, a lot of you just listen and that's cool, but at this moment, he's starting to increase his movement in this chair. He's swiveling it back and forth, back and forth. This to me lets me know he does not understand. He seriously does not understand what's going on. He's not in control. He's agitated because she's asking him too many questions. I'm more than positive that he had no idea that him wanting to represent himself would stir up all of this. Okay. I think that he thought he could just, his lawyers would file the waiver, he would answer a couple of questions, and that would be the end of it. Um, However, he is highly annoyed at this point in time, and this is childlike behavior. Anybody that's watched a child, like, I know when I take my kids to the doctor and they're nervous, I've noticed that they start to, shift in position. They're moving around, they're antsy or whatever. They can't focus, they can't answer questions clearly until their nerves have settled. This is the same thing I see here. He is in an uncomfortable situation. He's on full display. Nobody is talking to him but the judge. The cameras are on. Everybody in here has some level of education higher than his. They are all fully aware of the law, how it works, how to apply it, and he doesn't. And he is scared shitless. But again, his arrogance and his pride won't allow him to just ask for help, ask for new attorneys, or possibly even understand how to approach them as an adult to ask them to water down his charges, water down what this means for him, water down their defense strategy. And so he is just going to be disrespectful and swivel his little ass in his chair and becomes increasingly annoyed. So let's keep watching.
Hear me say that though.
Yes.
For the 2 counts of felony bail jumping, the maximum for both offenses is 12 years imprisonment. Do you understand that?
No.
Did you hear me say that though?
Yes.
For the 2 Class A misdemeanors, the maximum is 18 months, meaning 9 months plus 9 months. Do you understand that?
No.
But did you hear me say that?
Yeah, I heard you.
You heard me advise you of all of these penalties. Is that right, sir?
Yes, I heard you. Do not understand, but I heard you.
Sir, do you want to be represented by a lawyer in this case?
No, I do not.
Do you understand that you have a constitutional right to be represented by a lawyer in this case?
I'm aware that that is one of my rights under the Constitution, yes.
You understand that if you do not have enough money to hire your own lawyer, you may be entitled to have a lawyer appointed to represent you. Do you understand that?
I'm aware, yes.
I've already gone through the charges and the maximum penalties of imprisonment for all of these offenses. If you are represented by a lawyer, he or she may discover information or facts which would be helpful in your defense. A lawyer may find that you have a defense to the charge or that there are facts which may result in a lighter penalty. I want you to take this into consideration in deciding whether or not you want a lawyer to represent you. I also need you to understand that the trial will continue under the same legal rules that would apply if you had a lawyer. If you represent yourself, you will have to follow these rules. Because you are not trained in the law, this will make it hard for you to challenge the evidence presented by the state and hard for you to present any evidence that you want to present. If you decide to testify, you will be sworn as a witness and can give testimony while you are acting as a witness. You will be asked questions by the other side at that time. However, you cannot try to testify while acting as your own lawyer. Do you understand these things, sir?
No, I don't, because it sounds like pro se to me.
Because it sounds like what?
Sounds like pro se to me.
Well, there are two options here. Pro se means you act as your own attorney, you're self-represented. So when I talk about not having a lawyer, representing yourself, acting pro se, those are all the same. They all have the same meaning. Do you understand that?
No, I do not. My understanding that it's not the same meaning as representing yourself as pro per. And if that could be clarified for me, then it would greatly help.
Sir, under the Constitution, you have a right to have a lawyer and you have a right to self-representation. Those are the only two rights that I am talking
Aware
about
of that.
today.
I'm aware of that.
So whatever your understanding about some other hybrid fashion is not what I would be proceeding under. Do you understand that?
No, I do not.
What is your expectation, sir, about proceeding on your own in this case, in this pro forma, as you have said?
I simply seek to represent myself pro per so that I can establish my sovereign citizenship.
But what does that mean as to whether you have an attorney or not to you?
Clarify what you're saying, what you're asking.
You keep repeating this phrase, is it perf? Spell it for me.
Why is he getting so annoyed? Did y'all see how he rolled his eyes at her like, bitch? I said pro per. What are you not getting? Judge Darrell, don't do this to him, all right? Please. He said pro per. End of it. You in the wrong, not him.
Yes,
I
pro
want to
per,
make sure
yes.
that I have the right words that you're using.
You want me to spell for prior persona or pro per? Which one?
Tell me what you think you want to do in this case and what phrase or term that you're using and what it means to you.
Your Honor, I just stated on the record what I would like to do. I don't think
Spell it for me.
PROPRIAPERSONA.
And what does that mean to you, sir?
It means that I am representing myself as a sovereign citizen of the United States.
Does that mean you have an attorney or not have an attorney representing you, to you?
It means that I am representing myself in all legal matters. So that would say that I am my own attorney.
Do you understand, in order for me to honor that request of yours means you must waive your right to an attorney in this case?
Can you clarify that for me?
In order for me to honor this request of you to appear pro persona as a sovereign citizen, let me back up. What you're telling me is that you want to represent yourself and you're describing it as pro persona. Fair enough? Do I have that right?
Yes, ma'am.
All right. What I hear when you say that is you want to represent yourself and exercise your right under the Constitution to be your own attorney. That's what I understand your request to be. Am I wrong in my assessment of that?
No, you are not.
In order for me to recognize your request and grant your request, you must waive your right to counsel in this case. Do you understand that?
Is it case law on that that would give me clarification?
I can't give you advice, sir. I'm just asking you questions. All right?
From my understanding is, I don't see how that comes into play. I don't, That's why I'm asking, is it a way that that can be, that part of what you're saying, just that part can be clarified to me, because that was not my understanding, that there had to be some waiver of rights and
Sir,
things of
in
that nature.
order for you to represent yourself, you need to waive your right to counsel in this case. Do you understand that?
No, I do not, because it's not clear to me. Is that? a
You can't
way-
have it both ways, sir. You
I'm
either
not trying to have it
have,
both ways.
listen to
I'm
me,
just asking.
you either have an attorney and you're exercising your right to have an attorney, or you waive your right to an attorney and you act as your own attorney, what I refer to as self-representation. Doesn't matter to me what phrase you put on it. The Constitution guarantees you the right to have counsel, and it guarantees you the right to represent yourself. In order for me to honor your request to represent yourself and allow that in this case, means you must exercise, you must waive your right to an attorney.
Now, this, since you just broke it down that way, it's a little bit more clear. That's all I was asking.
I don't necessarily know, right, what's going on in your mind. That's why I ask a lot of questions. So do you now understand that, sir?
Yeah, I would like to weigh that right to counsel. I would like to represent myself from her, as I stated, yes.
Part of the decision I need to make, sir, is to evaluate certain criteria. It's why I asked the questions earlier, in part about your level of education, your level of literacy, your ability to communicate in the courtroom, etc. Do you remember me asking you those questions?
Yeah, I remember you asking me that.
So another thing that I have to evaluate those, sir, because ultimately I have to make a determination that you are knowingly, intelligently, voluntarily, and deliberately making a choice to waive your right to counsel and represent yourself. And in order for me to do that, I must establish certain things, including that you understand the charges and the penalties you face. Does that all make sense so far?
Yes.
You may have a lack of understanding about the nature of the charges and may have questions regarding that. But my role here today is not so much to explain all of those nuances and explain the basis for the charges, but to make sure you understand what charges you face and the penalties for them. Do you understand the distinction?
Yeah, it makes sense to me.
All right. So I'm going to go back to these charges again, sir. Do you understand you're charged with 6 counts of intentional homicide? I'm not, and let me preface, I'm not asking you if you understand why. I'm asking you if you understand that these particular 6 charges have been filed against you.
I'm aware.
And are you aware of the penalties if convicted, for each count of first-degree intentional homicide?
You said a lot of numbers, so.
Well, and I can go back to them, and I'm okay. This
No, we
is
don't need to-
important.
we don't-
So
we don't need to do all that.
first-degree intentional homicide is a Class A felony, and upon conviction, you shall be sentenced to imprisonment in life. Do you understand that?
I'm aware.
All right. And are you aware that there's also an enhancer for use of a dangerous weapon?
I don't understand that, but I'm
Are you
aware.
aware?
I'm aware.
All right. Are you aware that if a jury finds that you committed the offense of first-degree intentional homicide by using a dangerous weapon, that maximum term of imprisonment for this felony may be increased by not more than 5 years? Essentially, it adds 5 years for each offense convicted with that question being answered by the jury, yes. Do you understand? Are you aware of that?
I'm aware.
And are you aware, sir, that you face 61 counts of first-degree reckless endangering safety use of a dangerous weapon? Are you aware that each one of those 61 felonies, upon conviction?
So now she's talking to him at a level that he can fully understand what's going on. And so now you can see he's very pleasant. Okay. He's attentive. He's answering her questions without hesitation. He's not taking her around in the stance of, you know, giving her a difficult time while answering the questions because she's met him at his level of understanding and again handling him with child gloves, kid gloves, okay, so that they can get on with this proceeding. See how his personality shifts? So now he's not as aggressive, he's not as arrogant, he's cooperative, and I guess you could say easy to get along with for the time being. Let's move on.
And you may be fined not more than $25,000 or in prison not more than 12 and a half years or both. And are you aware that if convicted and the jury answers the question yes about using a dangerous weapon, each of those terms of imprisonment may be increased by not more than 5 years? Are you aware, sir, that you are also charged with 6 counts of hit and run resulting in death? And are you aware that each one of those Class D felonies is punishable by imprisonment up to 25 years?
Did you say 25 before?
I hope I did. If I didn't, it's 25 years. I'm reading it right from
I probably missed it.
there's a lot of charges and I understand that there's a lot of numbers.
Yeah.
But are you aware that a Class D felony for hit and run resulting in death is punishable by a fine of up to $100,000 and imprisonment of up to 25 years?
I'm aware.
Are you aware that you're charged with 2 counts of felony bail jumping? Are you aware that each one of those counts carries a maximum term of imprisonment of not more than 6 years and a $10,000 fine?
I'm aware.
Are you aware that you're charged with 2 counts of misdemeanor battery domestic abuse?
I'm aware.
Are you aware that each one, as a Class A misdemeanor, the maximum term of imprisonment is 9 months and a $10,000 fine?
I'm aware.
Are you aware that they're each charged as acts of domestic abuse so that upon conviction, there would be a domestic abuse assessment imposed?
That last part I don't understand. What exactly does that mean? The very last sentence.
Sure, it states as follows in the charging documents. That invoking the provisions of 968.075 sub 1 sub A, because this charge is an act of domestic abuse, costs upon conviction would include the domestic abuse assessment imposed under Wisconsin law. It's an additional $100.
Also, it's a fine.
It's a cost. It's a surcharge.
What is it called?
Technically, it's a domestic abuse assessment. It's a financial obligation, but when the court imposes it, it has some other collateral consequences that follow with it. I can't give you advice on what that is, but typically it involves prohibition of firearms. Are you aware of that?
Yes, ma'am.
Do you understand? Let me rephrase that. Are you aware, sir, that the state of Wisconsin is represented by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, and Assistant District Attorney Zach Witchow? The
Say
3 individuals seated to your left, my right.
Say the first part again.
Are you aware that the state of Wisconsin is represented by 3 attorneys here in court?
No, I do not understand.
Are you aware?
Not even aware.
So are you aware, sir, that the state of Wisconsin is the plaintiff in this case?
I'm not aware. This is where the confusion of that comes in. I have confusion to how the state can be the plaintiff.
I am not going to give you legal advice regarding that answer, sir, but you have the second amended criminal complaint. And if you don't, we'll give you the information as well. These are called charging documents, sir. And on the top of each,
So I think I read somewhere that his mom had a civil case that she was able to represent herself and actually won. I don't really like to talk about things that I can't back up with proof. So I'm not 100% sure if that's accurate or not. However, it is to be believed that his mom was the one that was giving him quote unquote legal advice during her daily phone calls with him before and after he went to court. And so that is why I think that he did not fully understand why the state of Wisconsin was the one that were bringing on the charges on behalf of the people. He thought that one or two, maybe more individuals would bring individual charges against him like they do in civil court. And so that is part of his defense strategy, as we learned throughout the trial, that he claimed he never once got an opportunity to face his accuser because there's no way that the state of Wisconsin can be his accuser because he didn't run them over. Okay. He didn't realize that, again, the state works and speaks on behalf of the people of the community. And so this is, again, I think, a strategy that he tries to use to throw the trial, even though this is a criminal trial and not a civil case. And so the reason why I brought his mom into the chat is because, like I said, I read that she at one point defended herself in a civil case, and so she probably told him to go in there and raise those specific concerns, and it's automatic that that case is gonna get thrown out, okay? Let's move on.
each one of those on page one, there's a caption. It says State of Wisconsin Circuit Court, Waukesha County. Do you see that?
I see that.
Do you see where it says State of Wisconsin plaintiff versus Darrell Brooks defendant?
Okay. This is why I'm confused. You have a lot of every document I ever got up until this point was like this with my name in all caps.
So what are you holding up? Is that the motion to withdraw?
Well, yeah, because it's the newest.
Right, so every legal document that is filed that's considered a pleading would have a caption. The caption is the information that says what court we're in, so it's circuit court, the county, Waukesha County, and tells the court who the parties are. The parties in this case are the state of Wisconsin as the plaintiff and Darrell Brooks as the defendant. Are you aware of that, sir?
No, I'm not. I need clarification on how the state of Wisconsin can be a plaintiff, because that would essentially mean that the state of Wisconsin is the injured party. How could the state be an injured party?
Sir, I am not going to go down this path of giving you legal advice. Are
I'm
you,
not asking for legal advice.
right, and I don't
I'm
need to
saying I'm
provide,
confused on how that can be. That's what I'm saying.
well, the bottom line, sir, is the state of Wisconsin is the legal entity represented by the Waukesha County District Attorney's Office that brings charges against a defendant.
Alleged defendant.
Well, no, you're a defendant accused of committing offenses. You're not an alleged defendant. You are a defendant, but the allegations are accusations. Are you aware of that?
No,
Are you now aware of it because I just told you that?
no.
Well, We're going to start with this premise, sir, that the state of Wisconsin is the plaintiff. They are represented in this case by the Waukesha County District Attorney's Office. There's many attorneys in that office, but the three attorneys who are prosecuting this case are the district attorney, Sue Opper, one of her deputy district attorneys, Leslie Basie, and an assistant district attorney, Zach Witchow. They have been seated at the other table, whatever courtroom we are in, throughout all of the proceedings, or the vast majority of the proceedings in this case. You're aware of that, right?
No.
You're not aware that these attorneys, these people seated to your right, have been in court virtually every time that you've appeared in court?
The guy just came like the last few court days. So I mean,
So you are aware because you made some observations.
well, the confusion with the question that you're asking is still, how can the state of Wisconsin be the plaintiff?
I'm not
How
going to
can
answer
it
that
be the
question,
injured
sir.
party?
I have a different reason for advising you. And what you need to know, what's important for my conversation with you today, is that the state of Wisconsin is represented by three attorneys.
Is that a judicial determination?
That is not. That's their prosecutorial discretion, sir. So,
So they're the
but what,
injured
hold
party?
on, nope. Let me ask you the questions and tell you certain things. What I want you to know is that the three attorneys appearing on this case have a collective, if I did my math right, 66 years of experience as attorneys. Did you hear what I said? Yes or no?
Okay, 66 years of experience as attorneys. Okay.
So now his attitude is shifting again because she is trying to inform him what he's up against. 66 years of experience. And now he's starting to feel intimidated by that because he knows he does not have any education beyond the 11th grade. Okay. He's never been to college. He has not taken any type of legal courses whatsoever. He definitely does not have the knowledge that they possess. He doesn't have the professionalism that they possess. And so now he's starting to feel intimidated by this. And so that inner child is getting ready to break free. We're getting ready to see him start to comment in those childish remarks that I told you guys about. And I believe this is due to his personality disorder or whatever. And so he doesn't become aggressive. He becomes very childlike and he's getting ready to make some statements that are just very immature and inappropriate for court.
So I'm gonna ask them a couple questions and I want you to listen carefully. Attorney Opper. Yes, ma'am. Has your entire career been as a prosecutor?
Yes, ma'am, since 1991.
See, he's rolling his
How many
eyes.
intentional
He's
homicides?
starting to roll his eyes. You notice that he's picked up the pace in that chair, baby. He's giving those wheels the business on that chair. He's rolling his eyes. He doesn't want to hear anything that they have to say. It has nothing to do with him whatsoever because he knows that he does not have a chance. He does not have a dog in the fight at this moment.
Homicide cases can you estimate for this court that you've been involved in?
10.
That's just before me. Is that how you took that question or is that total?
Oh, I'm sorry, total in the course of my career.
All right, so 10 intentional homicide cases that actually went to trial or just prosecuted in general? I wasn't very clear on my question,
That's
so.
okay. I would say probably 8 of those would have gone to trial. This is a ballpark, Judge.
Right. Suffice it to say, you are experienced in litigating intentional homicide cases.
Yes, ma'am.
You're also experienced in litigating reckless endangering safety charges.
Yes, ma'am, I've had many cases like that over my career.
How many trials do you think you've participated in over your 31 years?
I would estimate 200.
Attorney Basie, similar questions. You have, I believe, 27 years of experience,
I do.
all of that as a prosecutor?
Yes.
Can you estimate for the court how many trials you have been involved in?
125.
Very precise. Any of those intentional homicides?
Yes.
Any of those involve recklessly endangering safety charges?
Yes.
Now, Attorney Witchow, you're what we call the baby of the bunch. My understanding is 8 years of experience.
Yes,
All of that as a prosecutor.
yes,
Have you been involved in an intentional homicide trial before?
no,
In addition, Mr. Brooks, first of all, did you hear the answers to the questions I just asked these attorneys?
Yeah, I heard.
I mean, you understand, sir, they have a lot of experience sitting at that table. Would that be fair to say?
Roughly.
You also understand, though, that they have at their disposal an investigator with the Waukesha County Sheriff's Department, meaning they're assigned, that person's assigned to the district attorney's office to help them, even during a trial.
I don't understand where we're going with this.
Just want you to understand the resources that you're up against when you represent yourself.
Doesn't make me flinch one bit.
And I'm not asking you whether you flinch, I'm asking you if you understand it.
I still go back to the question I asked. I don't understand how they can represent an injured party. How can the state of Wisconsin, the corporate state of Wisconsin, be
Well,
an injured party?
I'm not answering that question. Okay, this is
So is
a
that a judicial determination that you're not answering that question?
No, sir. This is a legitimate case. And I'm not going to make a mockery by you asking that question. Because this case has been proceeding since November 23 of last year, and it's going to keep going on, whether you understand how the state can be a party or not. Do I make myself clear?
No, because the question is still there. It's still a relevant question.
I'm telling you, I'm not answering the question, and whether you understand the issue or not is not going to stop this case from going forward.
So is that a rush to judgment?
No. So I also want you to be aware that the district attorney's office has available, because the case involves witnesses from the city of Waukesha Police Department, that they will have seated at the table behind them, currently seated now, Detective Tom Casey. Are you aware of that?
I'm still going to refer back to the question.
Sir, answer my question. First of all, did you hear me ask the question? Did you hear me? Yes or no?
No.
So I'm telling you, Detective Casey is going to be their court officer throughout this case. Did you hear me say that?
How?
In addition to Detective Casey being here, the district attorney's office also has a support staff member that will be available for their use during this trial. Did you hear me say that?
Okay, so you guys know we have Sue Opper, Leslie Basie, Witchow. These three will be presenting the case on behalf of the state. This guy back here is the investigator, and so if they at any time need somebody to investigate something rather quickly, he has the ability to do so at any notice. This young lady back here is the paralegal. Shout out to her, paralegal. But she is the paralegal. So she is the one that can do research very quickly because she is trained in the law. She can research, she can file documents for them, she can retrieve documents for them, she can make copies. If they need something like Darrell Brooks and Sue Opera went back and forth with on the fly, she can do so. She can go and retrieve evidence. She can do anything that they need at any given notice. She is the assistant to the attorneys. They are responsible for presenting the case. She is their support person. Detective Casey is the one who helped investigate the necessary information for this trial. They have him at their disposal whenever they need to, hence the reason why he went ahead and was called to the stand twice. Okay. He did the groundwork for them as well. Darrell over here does not have anyone. He's getting rid of these two individuals. He will have nobody to help him. He is too childlike, immature to understand what she is telling him. Okay. She's telling him, you don't have what they have. They have three brains that at the end of every court day sit down as a collective and go over what the next day's strategy is based on what happened the previous day and the witnesses that they plan to call the next day. Okay. If they need something investigated, they have this person over here. They have the paralegal that will sit in with them to make sure that they're getting information that they will have had gone over. So in the event that like I said, if they need something right away, she knows what it could possibly be before they even let her know because she sat in on that meeting. He doesn't have anybody. He is not fully aware of how to locate different case law because he has not been trained in the area of the law. You got to go home and talk to your mother and try to anticipate what these 3 brilliant minds over here are going to discuss the next day. And so you're at a disadvantage because you don't know how to properly present the law, Daryl. You don't have the help like they have. You have your mom, and she's not trained in the law whatsoever. Just because, she can look up something on Google real quick, just because she allegedly had her own case, does not mean she's fluent enough to give you information to carry this case on your own. And he doesn't understand that. He refuses to understand that. He's so pissed with Judge Doro right now, okay, because now she's not talking to him in that manner that she was speaking with him with 15 minutes ago. She don't wanna hear any back talk or whatever. She doesn't wanna hear your opinion. You need to answer these questions. He's getting pissed again because he's not in control anymore.
I'm still not understanding how there are questions not being answered.
Sir, did you hear me tell you that right now?
Did the court hear me ask the question of
Mr.
how can the
Brooks.
state be a plaintiff?
Mr. Brooks, you
Is
gotta
there
answer.
some type
I'm
of
not-
case law you can point me
I'm
to?
not allowed to give you legal advice, nor will I.
I'm not asking for legal advice.
The whole point of this, sir, is that I need you to be aware that many people are going to sit on the other side of the courtroom working towards presenting this case and seeking convictions on all charges. Now, seated next to you are attorneys Perry and attorney Keys. My understanding of their experience, sir, is that Attorney Perry has been practicing for 20 years. Attorney Perry, is that true?
Yes,
All of that with the Public Defender's Office.
that's right.
You have experience both now in the trial courts and appellate courts. Is that true?
Yes,
And throughout that experience, you have litigated intentional homicide cases.
I have.
Also been involved in, I would imagine, cases where the charges involve recklessly endangering safety,
Yes.
hit and run, resulting in death.
Another thing that I want to point out too, really quickly, if let's just say somebody commits a crime and when they go to their arraignments, their first appearances, and their status is um God, what am I trying to say? There's the judge is taking into consideration their financial status. And if they're found to be indigent by law, you have to appoint them a court appointed attorney, correct? Part of that is, or how can I say it? Basically, what goes into that is the judge is going to be impartial. That's their job. And so they have to find an attorney with the experience based on the crimes that you're being charged with. So that's what really doesn't make any sense because at his first arraignment, um, of course, all of his charges were read and he was appointed these two individuals here. Both of them have experience with the charges that he's being charged with. And so there's no reason why to someone like you and I would not want them to represent you or I, right? He doesn't understand that. His level of paranoia is so high that he thinks that these two are against him and that they can't adequately put up a good defense for him, even though they have experience with the charges that he has. It is unbelievable. He is out of control, y'all.
Possible, I don't know.
Attorney Keys, my understanding is you have 12 years of experience,
Yes,
all with the public defender's office,
in criminal defense.
all in criminal defense. And you've been involved in intentional homicide cases as well.
Yes,
Suffice it to say, you and Attorney Perry have dedicated your careers to representing the rights of people accused of crimes.
yes,
Take that job very seriously.
I do.
Attorney Perry, same thing, right?
Yes.
Mr. Brooks, did you hear me ask your attorneys about their experience as attorneys?
Trying to understand what is the relevance.
Sir, did you hear?
The relevance is that you have two attorneys who work tirelessly to represent criminals such as yourself and make sure that their rights aren't being violated. Okay. Even though they may know that you are guilty, they still are passionate about client rights. That is the relevancy, meaning that regardless of whatever crime you committed, they have your best interest at heart. And they want to do their best to work hard to make sure you get a fair opportunity, okay, at a trial. Idiot.
Let me ask them about their experience.
The relevance.
Sir, did you hear me ask them questions about their experience as attorneys? Yes or no?
What is the relevance, Your Honor?
Since you're questioning the relevance, I will presume that you heard me and understand that you are seated next to attorneys who have dedicated their careers to the representation of individuals accused of crimes and that they're very experienced at that.
So you're assuming something that I did not say.
The other thing that I need to make sure you are aware of, sir, is what the state would have to prove in this case in terms of the elements of the offenses. I presume, but I want you to confirm that you understand the state of Wisconsin bears the burden of proof in a criminal case.
I'm not going to confirm anything until the question is answered, how the state can be a plaintiff.
I'm not going to answer that question, sir.
Can it be shown to me by some type of case law?
You currently have attorneys representing you. I have not discharged them. If you have questions about legal topics, you can ask them. I'll even give you a moment. I'll step off, give you a couple minutes, 5, whatever. If you need to ask them those questions, do you want that opportunity?
on the record.
He does not respect his attorneys because they are more intelligent than he is, and they are able to articulate thoughts and just articulate documents, read documents, comprehend documents. They know the law. They are well versed in the law. It is intimidating to him. Okay. He feels small compared to them. He does not know how to formulate his sentences well enough to convey his feelings, to convey whatever thoughts he has, to convey his questions to them. And he is unable to comprehend the way that they explain things to him. So he does not respect them because of that. So that is why he is not wanting to ask them anything because of that barrier. Okay.
I can pause.
No need to pause. Can the prosecution,
Sir, I'm not going, we're moving on. I understand you're not happy with the court not answering this question that you have, but I'm not going to answer it.
well, that's essentially a rush to judgment.
I'm not rushing to any judgment, sir. My concern here is to make sure that you understand the charges you face, the penalties that are associated with them, that you're aware of all of these things, that you are aware that you as a defendant do not have to prove anything at a trial. Are you aware of that?
I can't move past the rush to judgment. I-
There's no rush to judgment.
Just
Did you
assume-
hear me, sir?
You just assumed that I said something I didn't say.
We're going to move on.
How can we
We're moving
essentially
on, sir.
So I think this is where he first displays his opportunity to find some type of technicality based on the words that Judge Doral is using. And that's where the rush to judgment comes in, and him saying that she is assuming something that he did not say. And basically his defiance as it relates to the question that he wants answered. Um, he's trying to upset her so she can come out of herself, and he can use that as a technicality. Again, a skillful manipulator, skillful manipulator.
How can we do that though?
We are here at your request to represent yourself. We're going to move on because your question is not relevant to that inquiry. So I'm moving on.
But it's relevant.
And you
for
don't
me
have to
know.
like it.
No, it's not. It's not that I don't.
We're moving
I'm
on.
fine. It's just I find it hard for me to ask a question that's not relevant, but then it's relevant for me to know the
Mr. Brooks, we're
experience of
moving on.
everybody
And if
here.
you have the inability to move on, then this hearing is done.
It still has to be a determination made.
Sir? I would like to
Ma'am?
continue. So we need to move past this. And if you can't move past this, then I'm done.
Then I can still make the record.
Sir, do you understand that
Not.
the state of Wisconsin must prove each and every offense beyond a reasonable doubt?
No, I do not understand until my question is answered.
Sir, are you aware that
No, I am
the
not aware.
state, I didn't even ask the question. How can
I'm
you
not
answer?
aware.
Mr. Brooks, are you aware that the state must prove every element of each offense charge beyond a reasonable doubt in order for you to be convicted?
No, I'm not aware. The state still has, I'm still confused. How are they?
Right, Attorney Perry and Keys, we're gonna go off the record. I'm gonna take a break. I'll mute the live stream. I'll even stop it for now. I'm gonna clear the courtroom. I'm gonna give you some time to talk with Mr. Brooks. I'm not answering his question, nor am I required to answer his question. But I can't move past this if he is going to keep interrupting. He's not demonstrated thus far that he understands enough for me to even get past that to make a determination that he can waive his right to counsel.
Mhm.
I trust.
Uh-oh. Okay, I'm not sure what happened with the stream, but I'm going to stop it there. So as you can see, she can't go forth with the colloquy because he's ugh, sorry, he's being increasingly difficult with her. And like I told you, per the law, anybody that does not understand the proceedings, they don't understand the nature of what's taking place in court, you cannot force them to stand trial. And so he knows that. He is very well aware of what he's doing. Um, and so she cannot discharge his counsel due to his inability to cooperate. And it's just that simple. Let me know what you think. Let me know what you think. There's going to be a part two. The second part of this video, I am going to do a commentary on the second day where she tried to have the hearing again and ultimately did decide to allow Darrell to represent himself and she discharged the lawyers. However, I think he showed out even more, if I can remember correctly. I'm not sure. But I do appreciate any and all feedback as long as it's respectful. I do appreciate you guys so much. This channel has grown so fast, and I appreciate everybody for hanging in there with me. Um, it's important that I shout you guys out every single time. And my reason for doing so is because of two reasons. One reason, everybody that starts a channel ultimately wants to get that milestone of 100 subscribers. But the most important thing, I think, is those first 500 subscribers, I think, are just precious because those are your ride or die subscribers. Those are the one who are they're going to love you at your worst and cheer for you at your best. Those are the ones who don't mind your content being a little imperfect. Maybe the sound isn't right. You don't have all the equipment. If you go live, your background may not be perfect. You're still trying to learn the ins and outs of YouTube and just audio and things like that. But they appreciate the fact that you keep showing up and giving it your best. And so that is why I have to show my gratitude for each and every one of you for continuing to engage with me and help my channel grow. So, no matter how big or how small my channel is, please know that everyone is appreciated for everything that, excuse me, that you contribute via your comments, your likes, sharing, and leaving positive feedback. I do appreciate everybody. Okay. So y'all be easy. I will see y'all in the next video. And yeah, peace.